Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the founder and principal of the GTA family law firm, Feldstein Family Law Group. Both myself and our entire firm is dedicated exclusively to the practice of family law. Today, we're joined by immigration lawyer Adam Sadinski. Welcome to the show, Adam.
Thanks, Andrew. Happy to be here.
Well, we're happy to have you here today, and I'm going to run into the questions right away. And today, as you can see to the viewers, our topic is about the intersection of family law and immigration law. And it can be difficult for clients to navigate their legal matters when different legal fields intersect. Today, Adam and I are going to provide clarity, or at least some clarity, on how clients can navigate their legal matters between family and immigration law. So, to start, Adam, tell me what you do as an immigration lawyer.
Of course. So, my practice, I touch on pretty much every area of immigration law, specifically in terms of individuals coming from other countries to Canada, or folks who are in Canada and trying to stay here. So, this includes, uh, in particular, spousal sponsorship applications, work permits, study permits, refugee claims, and helping people from the point that they decide that they want to come to Canada or stay in Canada, up until the point that they get either a final approval of that visa or permit that they're trying to get to come to Canada, and through to following a rejection, appeals, or judicial reviews of refusals of those applications.
Okay. Now, when people apply to come to Canada, do they apply sometimes as husband and wife coming to Canada or husband or wife sponsoring the other?
hmm So there's a few different types of situations where a person's marital status or family situation is going to be relevant for their immigration application. So the classic example, and you raised it, Andrew, is a spousal sponsorship application. So there's two different types of these. So one is where you have a sponsor in Canada and they're sponsoring their spouse from overseas, so who lives in some other country, to bring that person to Canada as a permanent resident. And so the person in Canada is either a citizen or a permanent resident, and the person abroad does not have status in Canada. And then there's also in Canada spousal sponsorship applications where both individuals are in Canada. Sometimes the person who isn't a citizen or permanent resident, they might have a visitor visa or a study permit, but they're trying to remain in Canada permanently through that sponsorship. So that's the classic example that people think of. But there's also, for example, someone might be applying for permanent residence in Canada through some other stream, like express entry, which allows people to come to Canada for economic reasons, but they're entitled to bring their spouse or their children along with them. And so the spouse in that case is considered their dependent. And then that person, depending on the type of application, could be able to come to Canada with that person and either get permanent residence, or some sort of temporary status like an open work permit. And so it's always important in these types of applications, for people to be clear when they're applying to immigration about what their marital status is. To be clear about the date that their relationship began or that any previous relationships ended, because all of that information is going to stay with you throughout your immigration proceedings. And if there's any risk of misrepresentation of those dates or an overstating or understating of your relationship, that can run you into trouble down the line, either in your immigration application or in terms of family law.
So you gave me a lot to unbundle as it
Yeah,
plays into family law. So I'm going to try and work through it one step at a time.
sure.
When we talk about bringing over your spouse, and you said there's two ways. One is through a sponsorship, they're living abroad, or two, they're living here. Are those usually short marriages in that people just got married fairly recently when you see those type of sponsorships?
Not always. Um, Sometimes there are people who just got married and they've decided that they want to come to Canada. Other times it's a long relationship and people sort of have lived abroad for a long time. So a Canadian citizen may have gone abroad to work and married someone over there. And now they've decided that they want to come back to Canada. And so, in order for their spouse to join them, they're going to apply to sponsor them for permanent residence.
Okay, so I'm going to take this down a few paths. I'm going to start with
Sure.
the new marriages because people make a lot of faulty assumptions because they're getting married, they're happy, they think everything is going to turn up rosy. Now I'm going to put on the dark hat of the lawyer of almost 30 years who has seen what can happen. You sponsor somebody to come to Canada, they move into your home, you're recently married, and they come here and then they allege whether they did or didn't, because maybe it did happen, they allege all sorts of abuse, and then they make claims for spousal support. And the clients, when they come to me, they say, well, I'm only married a year. We haven't had any kids. And I look at the spouse support advisory guidelines and it's only generating a small payment. So I really don't have much to worry about. And I say to them, hold on a second. There are cases where the courts will say that's an exception to the spousal support advisory guidelines and far overshoot it because they feel bad for the person that relocated their life, then got abused here, and now is isolated from their family. And whether it happened or not, we don't know. It may have, may not have. But the payor finds themselves in a predicament of paying support far beyond what they usually would pay for a very short term marriage. So I caution people that when you had a short term relationship or it's an arranged marriage and you don't think it's going to happen to you, well, we've had the clients in it who thought the same thing. The other place that you really get into trouble with sponsorship when you're sponsoring someone to come here and they may have had a child, because correct me if I'm wrong, if you're sponsoring your spouse because maybe you recently got married and they may have a child from a prior relationship or prior marriage, you can sponsor their child as well. Is that
The
correct?
spouse comes, the child comes as a dependent.
Okay. And when they're providing the sponsorship, that sponsor is saying, I'm going to take care of that child. Am I correct? And
Financially.
yes, and one of the problems we get into is the sponsorship is usually for how long? How many years?
So when you sponsor your spouse to come from abroad, you sign a sponsorship undertaking that is valid for 3 years. And it doesn't matter if your marriage dissolves or you separate or you get divorced or even you get remarried. That obligation to sponsor that person, really what we're talking in terms of the undertaking is your spouse can't go on social assistance. And if they do, you're on the hook to pay the government back for what that person receives. So if you divorce, you still have that obligation for 3 years, and it's nearly impossible to get out of it.
Okay. And what I'm going to say to you is when you end up walking into my office and you've signed that undertaking for 3 years, you wish more than anything else that was all that you have to pay. Because what happens is if that person has a child, their lawyer is going to say that you demonstrated a settled intention to treat their child as your own by virtue of the sponsorship and the relocation. So now you're paying potentially spousal support for a lot longer and a lot more than what the spousal support advisory guidelines can have. And you may be paying child support for a very long time, depending on the circumstance. So these are very real obligations that you may be creating for yourself. So somebody makes a good income, they're thinking they're going to bring somebody over, they think they know them or it's arranged and or they don't know them that well. They bring them over, they start to live together, and wow, they find out it's not working. And that may end up being financially the worst decision they've ever made because the family courts don't say that the support is limited to the 3 years of what the undertaking is. And the family courts don't say that the support is limited to the same quantum of the undertaking being the equivalent of social services. And that's why I say that undertaking, you wish you could get away with that. That would be a huge win in my world if that's all you have to pay. So these are real issues. And I guess what I'm saying at the end of the day is if you are thinking of sponsoring somebody and you're thinking of bringing them over here, don't see it with just rose colored glasses and assume the whole world is going to be amazing. There are very, very, very real risks that you're taking on financially that go far beyond what the undertaking obligates you to. And I think it's important for people to be aware of. Now, you talked about a few other points in there. And one of them you talked about was a Canadian citizens abroad. They've been living with somebody for a number of years and they're deciding to move to Canada. That's another one. In that scenario, you're going to think that you know your spouse. And I stress that word think because lots of times we think we know our spouses and sometimes we don't. Part of the reason why I've been staying busy for 30 years. Now, when you get into that scenario, you take on a whole different set of risks. Now, I'm not going to profess to be a lawyer doing family law in every country in the world and every sub-jurisdiction like every state in the US. But here's what I am going to say if I'm a payor versus a recipient. As a general rule, Canada, and specifically Ontario, is a very generous support paying jurisdiction. If you're a support payor, you don't really want to be here. If you're a support recipient, you absolutely want to be here. And I'm going to give a couple of examples right now. And people may be thinking I'm talking about jurisdictions that are far off and don't necessarily have a rule of law like we do here. I'm going to start with the US. I could be wrong, but 46 of 50 states in the US have a cap on the guideline table child support amount. Here we really don't until you're into millions of dollars of income. So you could see yourself paying $20,000 a month in child support if you're a high income earner, very easily. It happens. Spouse support advisory guidelines. Again, even though it says the ceiling is 350, there's no real cap till you get $1 million. Support here is typically much higher than the US. So if you're thinking about relocating and bringing your spouse here, you know, if somebody phoned my office, and I'll give an example, and they lived in the state of Texas, where I believe, and don't quote me on it, that spousal support is limited to 3 years if you're married more than 10 and nothing under 10. And they said, the recipient says, we're thinking of moving to Ontario. I'd say, go pack your bags right away. And if you need to get sponsored, do it. Get here as fast as you can. And if the payor was calling me saying, I'm thinking of immigrating to Ontario with my wife, what should I do? I would say, stay far, 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 far away. Don't take the risk. This isn't the place for you from a family law perspective. These are things that I don't think people have thought about. But if you act, and whenever I get involved in a case where it deals with different jurisdictions, I usually have a conference call with the lawyer in the other jurisdiction. And just about every time, they can't believe when I tell them what the support is that the person will have to pay and why we're either trying to fight for or against this province and this country being involved in the family law case. So here you are. I get back to Adam's point. You can sponsor your current spouse, but if your current spouse is really smart, they may be trying to relocate to Canada because they're going to do really well. And I haven't gotten into whether the property regime here is better or worse than the jurisdiction they're in. It may be the same, it may be a different way, but there could be nuances that it's better or worse in the property regime. I say all of this as a backdrop because one of the things we as people often do is we ask the obvious questions. What would be the obvious questions, Adam? If I were to say to you, what do probably all your clients ask you when they come in for that kind of retainer, when they say, I'm married, I want my wife and I, we've been living in the US, we want to come to Canada, she's an American, I want to sponsor her. What are the typical questions?
Well, they ask, is she going to be able to work? How long is it going to take for the application to be approved? How long until she's going to become a citizen? These are some basic questions that they ask.
And not one of them ever say to you, well, what happens if she leaves me?
Yeah.
You know, and there's a reason. People aren't necessarily thinking that way, but it's reality. And just to give you an idea of the context of how ridiculous it is, I was talking to a very successful friend of mine that I once went to school with, and he said to me, when he lived in Ontario, he had a marriage contract prepared. Then he moved to a state in the US, and the difference in the laws was so drastic that he was the one trying to get the contract set aside because he would do better with the laws in that state than he would with the marriage contract he signed in Ontario to protect him. To me, that really says it all of the difference. And that jurisdiction said a deal is a deal is a deal, which we don't always say here in Ontario. So I'm highlighting these kinds of really sensitive points because if you're a viewer and you're thinking, should I immigrate to Ontario? Shouldn't I immigrate to Ontario? I'm really saying to people, you should think about hiring a family law lawyer and saying to the family law lawyer, what would be the impact if I moved to Ontario? And asking someone in your local jurisdiction, what would be the impact if I stay here? What's the difference? What's the difference? It's significant. And I can tell you right now, uh, if I thought my marriage was the least bit rocky, I wouldn't want to do it. If I was the payor and if I was the recipient, I'd want to get here as quickly as I could. And the same thing goes if I'm embarking on a new relationship. Some of our viewers may think, well, get a marriage contract. Well, guess what? You can't do a marriage contract that is necessarily binding with child support. And spousal support, the Supreme Court of Canada has said the contract has to be in accordance with the Divorce Act, both at the making of the time of the contract and at the review of the contract. So the contract has risks. Are these risks you're comfortable with? Is Canada really worth it? I'm raising all of these issues from an intersectionality perspective because, much to the point of the question I asked you a couple minutes ago, Adam, if I'm right, nobody thinks about it. Would that be a fair comment?
It's not something that usually comes up. When people are applying to sponsor their spouse, they're usually not asking me about an impending divorce. Sometimes they ask, what happens if we do get divorced? And then I'll give that advice from an immigration perspective, but they're not usually asking me about what they're going to be on the hook for in terms of payment other than their sponsorship undertaking.
And the other fascinating thing people have to understand is that some people will think that, well, we need to move there, we need to be there for a certain period of time. No, it's based on habitual residence. So if you've left the jurisdiction you're living in and then settled in Canada or settled in Ontario and you're here a week, 2 weeks, you may very well have created your habitual residence in Ontario and now you're bound by the laws of Ontario. And if I was a person who was in this situation, I would be very concerned. I mean, here's another one that I think is just tremendous when you don't appreciate it is, do you ever have people immigrating from Florida where one person lives in Florida?
I can't say that I have.
Okay. Well, in Florida, they don't recognize common law. So picture you're the payor and you've been in a 20-year common law relationship and you live in the state of Florida. You have no spousal support obligations. You move here, and I say 20 years very deliberately, now you're on the hook for indefinite spousal support at a significant amount of money. If I'm that person, I probably would like to have thought about that before I make the move. If I'm the recipient, I'm like, oh my God, if my spouse is an income earner, I just won the lottery, right?
Well, Andrew, it's interesting when you bring up the issue of common law because from the perspective of immigration legislation and family law legislation, the definitions of who is considered to be in a common law relationship are different. My understanding is that in Ontario, to be considered in a common law relationship from a family law perspective, you need to be cohabiting for 3 years. Whereas for immigration purposes, it's only 1 year. And then also on the immigration side, you can actually be considered to be in a common law relationship for the purpose of sponsoring someone, even if you're still married to someone else and you're in the process of getting divorced. If you are separated, you can start a new common law relationship and then bring your spouse or get some sort of status for your spouse on the immigration side from 1 year of cohabitation.
Well, it's interesting because you're right that family law says 3 years, but like everything else, there's often an exception. And the exception is if it's a relationship of some permanence and you've had a natural or adoptive child together. In that case, it can be less than a year. But the idea is you could sponsor someone at the 1 year mark and separate from them at the 2 year mark and not have any obligations of family law. I often think of that as that's a pretty difficult thing in your mind to be in a relationship that you know, in essence, has a best before date. You know, uh, from a family law perspective, what is common law now is very fuzzy because you could be dating somebody and be in two separate homes and spend 3 nights a week together. And there's a risk that a court could say you've been living common law, depending on the facts. And I remember after I separated from my first wife, and now I'm with my second partner, and in between, I thought to myself, okay, could you picture going and telling somebody that you're spending 2, 3 nights a week with that I want a contract because it could be argued that we're in a common law relationship. And if I don't have this contract, every relationship needs to have a best before date where if I met the person on a dating app, I need to go find the message I sent to them to show the first date and know that just to be cautious, I need to end the relationship within 3 years. But in a way, these are the kinds of twists and turns. Courts, if you're a high income earner with obligations, courts take you down that pathway. And immigration brings on these risks because of the sponsorship of the spousal support and the child support, like I said before. And just imagine if you come from a jurisdiction where you wouldn't have to give any property and you come to Ontario and you find out that a common law spouse may have a right to a joint family venture or may have a right if you're married to an equalization of net family property that's far more than what you would have had in the other jurisdiction. And it can even impact on custody. Some jurisdictions have rules that we find very funny about how you deal with decision making and parenting responsibilities, and it's very different here. So people need to understand about those issues, and it sounds like clients never ask you about that. Is that fair to say?
Doesn't come up so often.
Okay, I didn't think most people think that way. Most people aren't negative like I am in that sense. Now, in your mind, what would lead parties in a family law matter to seeking help of an immigration lawyer like you and vice versa?
Yeah, so I would recommend, and let me say that I know that there was a disclaimer at the beginning of this show, but the information that I'm giving is general and not legal advice. And if there is someone watching who needs immigration uh, assistance, you feel free to get in touch with me, but this is not legal advice. I would recommend that parties to a family law matter get the advice of an immigration lawyer really anytime there is one of the parties to the family law matter who does not have permanent status in Canada. Because you want to know, particularly if you are the person who is not a permanent resident or a Canadian citizen, what the implications of your separation are going to be. If you have a status that is tied to that of your spouse and you are going to separate from them, is there a risk that you are going to lose that pathway to being able to remain in Canada permanently? If you got a work permit because your spouse is a student and now you're going to separate, that when that work permit expires, are you going to be able to continue working or are you going to be able to return to your country? Another important thing, and there may be some people watching who may see themselves in this situation, is we see situations where there's an ongoing spousal sponsorship application and a Canadian citizen or permanent resident is sponsoring their spouse who lives in Canada but is not a citizen or permanent resident. And they're on the way to that sponsorship being approved, but now the relationship has soured and the relationship is breaking down, and sometimes there is abuse involved. And so the person who's not the citizen or permanent resident, they're stuck in a very tough situation where they know that their spouse is the ticket for them to get their permanent residence, but they may feel an obligation to stay in an abusive relationship. Now, this was a very big difficulty until a couple of years ago that the government now put in place what's called a temporary public policy that recognizes the vulnerability of these people and says to them, don't worry, that you have this ongoing sponsorship and your relationship is breaking down due to abuse, there is a certain type of visa that you can apply for called a temporary resident permit that is based on these factors, that you have an ongoing application that's tied to your spouse, but now your relationship has broken down due to abuse. You can apply for this temporary residence permit to get a new status not connected to your spouse. And then there's a pathway for you to apply for permanent residence on humanitarian and compassionate grounds. So in that case, that's somewhere that I'm going to be consulting with a family lawyer to say, what's going on with this relationship? Where is this going? Also, if there is a previous relationship, I'm going to ask a family lawyer potentially to confirm that a divorce abroad is valid. Or if you're bringing children, that a custody order from a different country is going to be recognized in Canada. So there are lots of different situations where a family lawyer might recommend that an immigration lawyer get involved, that an immigration lawyer recommend that a family lawyer get involved.
So that takes me to two questions I have on this point that jump off the page of me. Abuse can mean a lot of different things to a lot of different people. We have the concept of it in the Divorce Act. I'm wondering, have they defined abuse? Have they linked it to what's in the Divorce Act?
So it's not linked to what's in the Divorce Act, but abuse for the purpose of this temporary resident permit is described as physical, sexual, psychological, or financial, as well as neglect. And it's the discretion of an immigration officer who works for IRCC, Immigration, Refugees, and Citizenship Canada, to determine whether the context of this relationship is abusive within the interpretation of this program.
Okay. I think that's important for viewers to understand, especially if it's a viewer who was the one in the situation you described, that abuse can include psychological and financial. And it doesn't mean that you have to be able to show that you have bruises or that you've been physically assaulted, because some people, they come to that conclusion in their own mind that abuse must be physical and that it is a broader definition. The second place where I'm wondering is, let's say the person, and a lot of people who come to Canada come from countries where they're concerned about the government and what the government may do if you tell them anything. So they naturally don't trust government. And that being said, some of them, do they try and hide that the relationship is breaking down, maybe separate and think we're better off not to tell the government that this happened and try to get the sponsorship approved the way it is? And if that's the case, what are the consequences of not reporting the breakdown in the relationship?
So it's very important to keep the government of Canada updated on your marital status throughout any immigration process. And the first thing that I tell any of my clients when we're preparing a new application is that it is critical that all of the information provided in an immigration application is complete, true, and correct, and that remains so throughout the process. There's an ongoing obligation to keep IRCC up to date on your marital status. So I've seen clients burned where they have hidden a previous relationship, or they've fudged the dates on their either date of their marriage or date of a separation. And this comes up down the line, potentially in another application. Potentially, you've gotten remarried and you want to sponsor that spouse. But now when immigration is looking at your application and you're showing that, you and your new spouse were living together as of a particular date, and they have on file that you said you only got divorced from this other spouse later than that date. And now they put things together and they say, maybe your spouse before may not have been entitled to a status because you actually weren't living together, or you may not have been entitled to your status because you weren't living with your spouse. Misrepresentation can stay with you for a very long time, and it can cause a bar of 5 years for applying for permanent residence after an allegation of misrepresentation by the minister is approved. So I tell all of my clients, the government of Canada will figure out at some point what the truth of your situation is, and hiding it is always worse than telling the truth, explaining your situation, and always, if there's a situation like this where you're not sure what the implications of making a particular application or not, or disclosing information or not, seeking the advice of experienced counsel on the immigration side as well as the family side to help you through that process and make sure that what you're doing is not going to prejudice you down the line.
Adam, I want to thank you. We've now run out of time. We hope our viewers have got an idea of how to navigate their matters with both family law and immigration law are at play, and how family law lawyers and immigration lawyers can assist their clients with these challenges. Again, thank you for being here today, Adam. Adam's a terrific immigration lawyer who I recommend clients to see. If you're looking for assistance as part of your separation or divorce, please feel free to contact us and take a look at our website, separation.ca. The next Ask Andrew show will be on Tuesday, February 27th, 2024, at our usual time of 12 noon. And if anyone has any suggestions or ideas for further shows, please email them to us at info@feldsteinfamilylaw.com. And thanks for watching.